We'll start the hearing now. This is originating application 192 of 2023, Babel Holding Limited, originating application 193 of 2023, Babel Asia Asset Management Private Limited, originating application 194 of 2023, Babel Block Limited, originating application 195 of 2023, Moon Alpha Financial Service Limited, originating application 196 of 2023, China Trading Services Private Limited.
Good afternoon, Mr. Alex Chiu, Mr. An Liang, Ms. Yeo Zening, and Mr. Edwin Tiong for the applicants, correct?
Yes, Your Honor.
All right, good afternoon, Mr. Abraham Verghese, Senior Counsel, Mr. Nawaz Kamil, Mr. Alcion Yong, and Mr. Daniel Huang for DRB Panama, correct?
Yes, Your Honor, and with your permission, may my trainee, Mr. Liu Erning, join the proceedings.
Yes, thank you.
I also have with me my instructing solicitors, Mr. Robert Child and Mr. James Comber.
All right.
From first.
All right, thank you. Logo, we have Mr. Daniel Cha, Mr. Jonathan Tang, Ms. Charlene Wee from Morgan Lewis. Right. Yes.
Yes, Your Honor, confirm.
All right, thank you. Mr. Tiong Teck Wee, Mr. Ng Wei Xiang for OUE Commercial from One Partnership.
That's correct, Your Honor.
All right, thank you. Parastate Labs, Mr. Chu Hua Yi from FC Legal.
Yes, may it please the court.
Yes, thank you. Mr. Chu Cheng Si, Ms. Carol Yuen for Mr. Wang Li. And together with your practice manager, Mr. Dixon Chu, correct?
Yes, Your Honor.
All right, thank you. All right, thank you. Let me just administer Zoom allocation. So parties are reminded there is to be no unauthorized photography or recording in any form and no dissemination of any photographs or recording of these proceedings, and only those counsel or persons notified to the court should be present in each location, and parties should treat these proceedings as they would a physical hearing. All right, I've received submissions from the applicants, of course, and DRB Panama. Can I confirm that none of the others will be making submissions this afternoon? Mr. Chia?
It's only to state our client's position in respect to Motora. No submissions.
No submissions. Mr. Mr. Tiong? Any submissions this afternoon?
Nothing from us, Your Honor.
All right, Mr. Chu?
No submissions, Your Honor.
All right, thank you. Mr. Chu or Ms. Yuan, anything?
Nothing from us as well, Your Honor.
Thank you. All right. All right, thank you. Let's proceed then with the various applications. Mr. Yeo, you have your sealing applications. I guess logically we should start with those.
Yes, thank you, Your Honor. And just to address some housekeeping, I also have foreign counsel from Kirkland and Ellis. May have permission for them to sit in.
Yes.
Thank you, Your Honor. Your Honor would have seen two sets of sealing applications filed covering essentially the same subject matter, which is essentially sealing of the names of creditors in, firstly, the top 20 creditors lists, secondly, the letters of support, and third, the letters to court which list creditors. So Your Honor would have seen we filed a redacted version, which is available to all parties. And we also submitted an unredacted version to Your Honor. The two sets of sealing applications, well, there are two sets, first of all, because when we filed the original sealing application on the 13th of March, we included an unredacted version of the top 20 list of creditors and certain letters of support. After that, to give full and frank disclosure, the applicants and their financial advisors, Houlihan Lokey, reviewed the lists and found that some related party creditors had inadvertently been included. These are primarily employees, Your Honor. Essentially, I think the confusion arose as to whether their employees are considered related under the Contuba or SK Engineering Court of Appeal test. But to be safe, we have just blanket excluded all employees. And we filed the second set of sealing applications on the 30th of March to contain a revised top 20 list of creditors, and also to cover further letters of support that we had received after that.
All right, and the basis for your application to seal, please?
Your Honor, it is twofold, Your Honor. Firstly, to prevent essentially the risk of contagion, where Your Honor may have seen that when, for example, in the FTX saga, when Genesis was revealed to be a major creditor of FTX, that caused essentially a run on Genesis as well. The basis on which the first basis is to prevent a similar contagion effect on creditors of the applicants in this case. The second basis, Your Honor, is that essentially the list of creditors that we are required to submit, the top 20 list and so on, are essentially the largest, that is our client's customer base, Your Honor. So the problem with disclosing that is that essentially a customer list is in itself very commercially sensitive information. Now, Your Honor would have a set of my written submissions on this, and I don't intend to belabor all of it, Your Honor. I just want to draw Your Honor's attention to essentially three very discrete things, three very discrete points. Your Honor, I will start at paragraph 10.
Yes.
Your Honor, this is just quoting the test from True Yoga, a Singapore decision, which dealt with sealing. And essentially, the test was that the court will only order papers to be sealed where there are strong public reasons in the public interest to do so. The second point I will make is at paragraph 9 of the same submissions. This is the case of Design Studio Group, also a Singapore decision, holding that there is a need to protect commercially sensitive information in restructuring, and the public's need for access to restructuring proceedings may be perceived as less pressing in other types of cases, as compared to other types of cases such as criminal matters. But, of course, with the caveat, restrictions on disclosure should not be placed as a matter of course without good justification. And the third, Your Honor, is just to bring Your Honor's attention to US case law, where similar sealing of the names of creditors has been ordered in several US decisions. And I will also highlight an adverse decision where the court held that, notwithstanding all those previous decisions, that sealing will not be ordered. So I'm referring, Your Honor, to paragraph 13(1)(3) of my sealing submissions.
Yes.
I will start with subpara 1, which is INRI Cred, Inc., where the Delaware court granted a motion to redact the names of customers, including those in the top 30 list of creditors. And it was to redact the names, mailing addresses, and email addresses. Now, I will disclose at the outset that the court did not set out in its order the reasons why this redaction was granted, but Your Honor would have seen from the submissions, which we also included in the bundle, that the primary basis on which the sealing order was sought in the first place, and Your Honor can see this at the bottom of page 9 of my sealing submissions, was that public dissemination of the customer list would interfere with the debtor's ability to sell their assets and maximize value and place the debtors at a competitive disadvantage, and also needlessly place individual customers' highly sensitive personal information in the public record. Your Honor would see a similar decision based on a similar primary basis in FTX on the next page. I don't intend to go into that in detail. On the next page, Your Honor would see same order in Reblock FI. And again, the bankruptcy court did not elaborate on their reasons in the order itself, but Your Honor can see at the bottom of page 11 that the same basis was cited, where essentially competitors would try to poach the debtors, investors, and client list. Next page is Revoyager. Now, I will disclose at the outset that Revoyager was a case where, yes, names and addresses were redacted, but this was essentially due to fears of hacking. Now, I have also highlighted the adverse authority, which is INRI Celsius Network, on at paragraph 14, where Celsius essentially noted several previous cryptocurrency cases where sealing had been granted. It described Revoyager. It described InRecred. It described Altergrity, which is not a case I have cited to Your Honor. But at the bottom of the page, Your Honor can see the strong public policy of transparency and public disclosure in bankruptcy cases requires very narrow exceptions and only on very strong evidentiary grounds. The court concludes that the debtor's evidentiary showing is insufficient to justify the wholesale sealing of creditors' identities, and says that all parties and the public share an interest in complete transparency, except in the rarest of exceptions.
All right. Which jurisdiction is Celsius from?
Your Honor, this should be the New York Bankruptcy Court, but let me check that very quickly.
All right, thank you. Carry on, please.
Yes, Your Honor. Your Honor, notwithstanding the holding in Celsius, we submit that, Your Honor, just to address Your Honor's question, it was the Bankruptcy Court for the Southern District of New York.
Right.
Yes. Your Honor, just to conclude, on paragraph 16 of my submissions, in this case, we submit that Celsius should not be followed. Well, first of all, it's not representative of the law in America because of all the other decisions. In fact, several of the other decisions I have cited to Your Honor post-date Celsius. Secondly, Your Honor, at paragraph 16, as I've noted, the creditors identified in the top 20 creditors list are the main and/or largest customers of the Babel Group. Because what we have done is disclose the top 20 list of each entity. For some of the entities, the top 20 list is the entire customer group. This represents a unique and valuable asset of the group, and disclosure would therefore affect the business. Unfortunately, I have to say that derived is a competitor. So the fact that it is derived pressing for disclosure is troubling, Your Honor. The next thing that I would say is that there is a risk of contagion here, that specifically for cryptocurrency companies and investors, there is significant negative market sentiment affecting crypto companies, and therefore a risk of contagion, otherwise known as a knock-on or spillover effect. And I've already highlighted to Your Honor that the same thing happened for Genesis in the FTX filing. Your Honor, we have also received several letters from customers, from creditors, specifically requesting anonymization for essentially these reasons. And lastly, Your Honor, very last thing that I want to deal with in the sealing application is essentially the possibility of prejudice to creditors. We have submitted that there is no apparent prejudice to redacting the names. Since then, we have, of course, we have received objections from derived, saying that this makes it impossible for the court to determine whether parties are actually a creditor or whether they may be related. We have hopefully addressed that issue, Your Honor, by proposing two safeguards. Firstly, Your Honor, the applicant's financial advisors, Houlihan Lokey, in my submission, a very respectable, well-known name, have confirmed that the top 20 creditor list does not contain related parties based on their review and information gathered by them from their appointment in July 2022. Your Honor will see that at paragraph 20 of my submissions. Second safeguard that we proposed, Your Honor, is that we have expressly proposed that at a further point down the road, a scheme manager will be appointed who will not be Houlihan Lokey. So there'll be a second layer of advisors, essentially independent parties who will review and adjudicate upon proofs of debt filed by scheme creditors, and they will have full access to identifying information. The last potential prejudice to creditors, which was identified by derived, was that creditors may not be able to identify and consult with each other. Your Honor, my clients respectfully disagree with this, only because, as Your Honor would have seen from derived's affidavit, the only reason why they've been unable to consult with other creditors to date is because they refused to sign the non-disclosure and standstill agreements that would have allowed them to take part in discussions with creditors. Your Honor, that is, they've explained why they didn't feel it was appropriate to sign the non-disclosure or standstill agreements. For example, for the standstill agreement, they said, look, a standstill is not necessary. But Your Honor, given the amount of resources being poured in to try to restructure these companies successfully, if any creditor were to, like derived, essentially commence proceedings elsewhere or threatening to commence proceedings elsewhere, then that would torpedo the whole process. So hopefully Your Honor understands why we included a standstill agreement as part of sort of the entry requirement to take part in these discussions.
All right. Anything else, Theo?
Nothing further on sealing, Your Honor. Thank you very much.
Let me turn to David, but I just want to flag for parties that I am not likely to give a final decision today. I will probably give interim orders in the meantime while I consider the matter further. All right.
Understood. Sorry, Your Honor, there was one final thing. My humble apologies. I should disclose to Your Honor that since we filed the sealing applications, certain creditors have in effect identified themselves in open court proceedings.
All right.
Well, one example obviously is derived itself, which filed opposing affidavits and submissions identifying themselves. I stand guided by Your Honor. I'm happy to leave them out, or continue to have them sealed. I am in Your Honor's hands there.
All right. All right. Thank you. Mr. Burgess?
Your Honor, at present, all the confidential information has already been redacted. And so you then have to ask the question, what is the purpose of the sealing order? Because right now there's nothing confidential in the records. And we were actually under the impression, I take it wrongly now, that in applying for the sealing order, they were going to supply the unredacted version of the top 20 list and the letters of support. But if my learned friend is taking the position that derived is a competitor and therefore they should not be shown this information, that means even after the sealing, the applicant is still intending to keep that information redacted. Now, on the question of whether derived is a competitor, my instructions are that they are not. The applicant, Moon Alpha in particular, was a customer of derived. Derived runs a crypto derivative exchange. I don't believe Moon Alpha is in the business of running a crypto derivative exchange. So the suggestion that they are competitors and therefore there is sensitivity in sharing that information with derived is something that probably needs to be looked into more closely. Those are my submissions, Your Honor.
Right. Thank you, Mr. Burgess. Mr. Yeo, anything to respond?
Your Honor, just to correct one factual point, which is that we had filed the unredacted list in a further affidavit with the court. That is the affidavit which is sought to be sealed.
Yeah. All right. All right then. As I indicated, in various cases, this is always something that requires a balancing of interests. In the interim, until I give the final decision on this and the main application, I will give interim sealing orders. I'll grant interim sealing orders in the meantime. I hope to be able to give the final determination about a week or two.
Understood, Your Honor.
All right, thank you. All right. Let's
Your Honor?
proceed then, sorry, to the main applications.
Yes, Your Honor. Thank you. Your Honor should have, first of all, just at the outset, as a matter of housekeeping, we wrote to the court on 22nd March to say that we will be withdrawing prayer 1, subpara Roman numeral 6 of OA 193. That is essentially the landlord moratorium, Your Honor, that there be no right of re-entry or forfeiture under any lease in respect of any premises can be enforced. We wrote to say that we will be withdrawing that specific prayer. Your Honor, this arises from discussions between the applicants and the landlord in Singapore. I wish to confirm at the outset that we will be withdrawing our that specific prayer, Your Honor.
All right, thank you. And that, of course, would be, OUE, was it?
Yes, Your Honor. That would be Mr. Tiong of
All right, thank you. All right. Carry on, please.
Thank you, Your Honor. Your Honor should have before you a set of submissions dated 29th March in the main applications themselves. Your Honor, I don't intend to go through everything line by line, but it would be helpful if I start with the business of the group, Your Honor. That would be at paragraph 6 onwards of my written submissions. And just in very, very brief summary, Babel Finance, which is Your Honor would take that as a reference to the rest of the group, was preceded by Moon Alpha, which is one of the applicants before Your Honor today. Moon Alpha actually didn't carry on significant business until July 2018, when it launched an online mobile application for crypto lending named Private. We have disclosed at the outset that these were Hong Kong law governed user agreements, where Moon Alpha provided crypto services via this private application and later on offline transactions. But what happened after that, Your Honor, is that Moon Alpha evidently took off, and the two founders, Mr. Wang Li and Mr. Yang Zhou, wanted to offer a wider range of services in the global crypto market. And so what they did was they set up a new holding entity incorporated in Cayman Islands, that is Babel Holdings, another of the applicants before Your Honor today. Now, Babel Holdings is the holding company of a wider group of subsidiaries. We have disclosed in the affidavit that this includes several subsidiaries which are not applicants before Your Honor today. But if I just focus on the key subsidiaries which are before Your Honor would see that at paragraph 9. And Your Honor would see at paragraph 9 that essentially the range of business activities can broadly be divided into two. One is cryptocurrency lending, and the other is crypto asset management. And that will include crypto derivatives and trading. Your Honor will see also at paragraph 9 at the subparagraphs the list of what role some of the key operating subsidiaries which are before Your Honor today dealt with. So Babel Block at 9 subpara 1, engage in crypto lending, crypto asset management, crypto trading businesses. Babel Asia Asset Management, incorporated in Singapore, undertook digital asset management services. And Shinar primarily engaged in crypto asset management businesses. Now, before I go into the later debt or liquidity issues, there are two important points that I would like to highlight. The first is, Your Honor, and we dealt with this extensively in the affidavit, that what the group did was somewhat similar to the previous case Your Honor saw in ZipX. They consolidated all of their cryptocurrencies holdings into accounts, some of which held by Moon Alpha. They consolidated all of it together. They did not maintain at the time standalone accounts. They prepared their accounts on a group basis. Your Honor would see that at the first affidavit of Yang Zhao. Your Honor, I will just give you the paragraph reference without bringing you there. It is paragraph 69 to 73. And the most important point to note, Your Honor, is paragraph 73, where my clients frankly disclosed that they, after certain forced liquidation of accounts and also by reason of this consolidation of accounts, they are now unable to, without enormous expense and disproportionate expense, sort of unravel which entity owns what. So that was the very first disclosure that I wanted to give Your Honor upfront, and I will be dealing with this in further detail later on in the submissions. The second point I wish to note, Your Honor, is that Mr. Young had stepped down as CEO, and he ceased to be involved in business day-to-day management from October to December of 2021. Again, Your Honor, I will just give Your Honor the point site. That is in the first affidavit of Yang Zhou at paragraph 21. And from that point on, it was Mr. Wang who had been involved in day-to-day management. I will now turn to paragraph 10 of my submissions, where I'm still on essentially background facts. Your Honor, the group achieved unicorn status in May 2022, but the problem is from June 2022, Your Honor would have seen that there was essentially a crypto crash. Now, the crypto crash caused a number of problems. One of the major problems being the forced liquidation of several sub-accounts conducted by derived, as my learned friend pointed out, a cryptocurrency exchange. The losses were also caused by, and Your Honor would see that we also fully and frankly disclose this upfront. It was also caused by certain proprietary trading activities, which were not essentially taken into account when the group managed their risk every day on a day-to-day basis. And Your Honor would see that disclosure. I'm again just going to give Your Honor the point site. It's at paragraph 90 of these written submissions. And Your Honor would also, as Your Honor probably is very experienced with, this caused a number of margin calls from counterparties when the cryptocurrency market crashed, and that led to a serious deterioration in its financial position. Your Honor would see that we set out the order book deficit of US 783 million across the group. At paragraph 12, we say that our total assets on a gross basis, without taking into account any set-off, which some of our, quite a lot of the contracts actually permit, the group's total assets amount to US 740 million, and the liabilities are 1.5 billion, including contingent and prospective claims. But Your Honor would also note that we expressly said that after set-off, this position is likely to look a lot worse, in that the net liability position will stay the same, 783 million, but the total asset figure will drop. Your Honor, that brings us to the restructuring here. Your Honor, we distributed at paragraph 14 of my submissions, we distributed an initial restructuring plan on August 2022. We then distributed an addendum on the 26th of October 2022. Your Honor would note that that date is quite significant because, as Your Honor probably knows, the MAS on the 22nd of October had announced that they were going to be tightening regulations on crypto, which was one of the features which led us to produce that addendum, Your Honor. Your Honor would have seen that essentially the restructuring plan involves, among other things, it is not the only form of recovery, but among other things, it involves the issuance of Babel recovery coins. These are intended to be secondary tokens, which are going to be traded. And we've set out essentially how the issuance is going to work in quite a significant amount of detail. Your Honor would see at paragraph 15 of my written submissions that we also intend to propose a deed poll structure that combines all of the applicants into a single scheme application. Under this deed poll structure, one of the applicants which are incorporated in Singapore, Babel Asia Asset Management or Shina, will become the primary co-obligor, in respect of the scheme claims against all applicants. And we've elaborated on this again below as well. Your Honor, the issue is that in coming up with this restructuring plan, we do need more time. Your Honor would have seen, first of all, that yes, we have taken a significant amount of time. Withdrawal ceased in June. But Your Honor, the number of statutory demands and proceedings which have been issued by various parties have mounted over those months and have accelerated in recent months. Significantly, Your Honor, and I will disclose this is not on affidavit because I only found out about it today. Derived has commenced proceedings in the Dutch courts. In addition to their earlier statutory demands, which threaten winding up proceedings in Hong Kong. So, Your Honor, that in essence is the factual background which brings us to the application here. Your Honor would be even more familiar than I about the applicable legal principles for scheme applications generally, so I wish, with Your Honor's permission, I will skip all of that. And I will skip straight to essentially the application to the facts. That would be at paragraph 28, Your Honor. At paragraph 28 of my submissions, we submit that the statutory requirements of ERDA are satisfied. First of all, we start with whether each applicant is a company with the requisite standing to bring this application. For 2 of the 5 applicants, they are incorporated in Singapore. So hopefully that should not be an issue. Those 2 applicants, there's a typo here at paragraph 29 of my submission. Sorry, we referred to Moon Alpha and Shina. It should be Babel Asia Asset Management, BAM, and Shina. Those are the 2 companies incorporated in Singapore. At paragraph 30, we set out which are the foreign applicants. That is Babel Holdings Limited, the holding company, Babel Block Limited, and Moon Alpha. But we submit that there is a substantial connection to Singapore. And we set out why at paragraph 34 of my submissions. For Babel Holdings Limited, that entity wholly owns Babel Asia Asset Management, a Singapore incorporated company, and therefore has a substantial asset in Singapore. As for the rest of the group, there's a Babel finance team which serves the entire group, which works out of Babel Asia Asset Management's registered office in Singapore, and conducts business in Singapore. So by reason of this, each of the foreign applicants have clients and creditors in Singapore. Third, we set out that the current sole director of each of the foreign applicants, Mr. Yang Zhou, is resident in Singapore. Your Honor will recall that he stepped down previously, but he returned to the group, essentially when they ran into trouble, to try and help things out. And he is now the current sole director. And the other gentleman, Mr. Wang, has since stepped down, and we've taken measures to make sure that he's not involved in management. Your Honor, at paragraph 34, subpara 4, we should disclose that even though each of the foreign applicants had been carrying on business in Singapore, they had not registered as a foreign company on ACRA until fairly recently, on the 23rd of February, 2023. Your Honor would have seen from the affidavits that we gave full and frank disclosure of this upfront. Your Honor, finally, the foreign applicants have substantial assets in Singapore because the private encryption keys required to access the cryptocurrencies of the group are controlled by management personnel in Singapore. Your Honor would recall that this is I suppose the usual issue which arises, which is where's the lex situs of crypto assets? Helpfully, there's a recent decision on this, albeit from England, not Singapore, in Osborne versus Persons Unknown. Your Honor would note that there are actually 2 Osborne versus Persons Unknown decisions. One was on the 10th of March 2022. That was the one cited by my learned friends in their submissions. That was the earlier decision, Your Honor. The later decision is the one which is cited at paragraph 37 of my submissions. And it essentially holds two things. On the next page, Your Honor can see from the quote from Dicey and Morris. I accept that there's a good arguable case. I was not referred to Dicey and Morris, but I note the following. Dicey and Morris said that the law is still in its infancy in confronting the problems raised by these technological advancements. In Ion Science versus Persons Unknown, the court determined that there was a serious issue to be tried, that the lex situs of cryptocurrency would be the domicile of its owner. It may tentatively be suggested that a solution based around the owner's location is indeed the best fit. The location of the owner is readily objectively identifiable, although given uncertainties around identification of domicile in different cases, habitual residence or place of business test would be preferable. But more importantly, Your Honor, that it goes on to hold a second thing, which is the owner of a cryptocurrency has control over the property, generally through their control over a private encryption key. The owner should generally be understood, therefore, to refer to the person in possession of the private encryption key giving access. So, Your Honor, I will accept my learned friend's submissions spoke about how the owner of crypto in this case has not been established or is in dispute. But this case makes very clear that they're not talking about the legal owner, they're talking about the person who has control and possession of the private encryption key. That is what the term owner means. Your Honor, in this case, the individuals who control the private keys are working out of Singapore. And therefore, my submission is that is the lex situs. But Your Honor, just in terms of substantial connection, I will just say one last thing on substantial connection, which is we've received objections from two creditors to the Singapore court asserting jurisdiction. The first from Derived, saying that Moon Alpha should only be subject to Hong Kong court filings. And the second from Lisk Foundation, which has asserted that the courts of the BVI are the better forum. Your Honor, my respectful submission is just this, that it would be absolutely impossible to properly restructure this group if some applicants incorporated in the BVI can only file in the BVI, which is what Lisk Foundation is suggesting. Then Moon Alpha can only file in Hong Kong, as Derived is suggesting. And then the Singapore-based applicants presumably can only file in Singapore. That would be absolutely impossible, Your Honor. Your Honor, the conditions laid out in section 64(2) of ORDER are also satisfied, that no order has been made and no resolution passed for the winding up of the company to our knowledge, and that the company has made or undertakes to make, in our case, undertakes to make as soon as practicable, an application for leave to convene scheme meetings. Your Honor, I will highlight at this juncture that the strict wording of the section seems to imply that each applicant must say that each applicant will be filing a scheme. That would not be the case in a deed poll. In a deed poll scheme, only one of the 5 applicants will be filing a scheme application. But I submit that the spirit of this requirement in section 64(2) must be met by such a scheme. If deed poll schemes are permissible, surely that must be within the wording of section 64(2). Third, Your Honor, we have given notice of the moratorium applications in the manner prescribed. We had actually advertised and gazetted, and we have kept the court updated and creditors updated. We've kept the court updated on the steps we took to give access to all creditors via virtual data room and regular emails announcing the uploading of new documents to the virtual data room to all creditors. Your Honor, we have also received certain letters of support. Now, I will highlight at the very outset that the percentage in terms of value of these letters of support are not high. For Moon Alpha, for example, as derived has highlighted, it is 0.8% of in value of the overall creditor pool. That, to my knowledge, I think that's probably the worst of the applicants. Your Honor, I will now turn to whether we have provided sufficient particulars of the intended compromise or arrangement. This is now at paragraph 50 of my submissions. Your Honor, my submission is that we have provided sufficient particulars and details of the intended compromise. We have set out in quite great detail how Babel recovery coins or tokens would be issued. We have also enclosed the restructuring plan and the addendum to that restructuring plan, which was issued 4 days after the MAS circular, which contains in about 15 to 20 presentation slides, details of what the restructuring plan is. But just to refer Your Honor to where it appears in the affidavits. Just give Your Honor, I will give Your Honor the citation. It is paragraph 94 of the first affidavit of Yang Zhou in Babel Holdings filing. That would be OA 192. And if you, with Your Honor's permission, I would like to turn Your Honor to this very document, just because of its importance. Your Honor would have seen that the plan would involve the issuance of Babel recovery coins as consideration based on the relative amounts of each creditor's claim or deficit balance. The deficits, basically creditors' claims, will be converted into a BRC in the form of 3 denominations depending on what their underlying claim was. So first denomination is for Babel recovery coins dash Bitcoin. Second is dash Ethereum. Third is USDC. And the Babel recovery coins will be designed to be compliant with the ERC 20 standard for creating and issuing fungible tokens, just essentially so that it can be traded, Your Honor. Second, Your Honor, we have specifically said that BRC will be distributed to eligible creditors as scheme consideration. Important emphasis here on eligible creditors. There are certain creditors who may be non-eligible creditors, essentially that they cannot hold BRC. Your Honor would note, as Your Honor knows, China has essentially passed laws which do not allow their residents to hold crypto. For such non-eligible creditors, there will be a holding period trustee who will hold on to BRC entitlements on behalf of the underlying creditors. Creditors are expected to be able to monetize their BRC holdings in one or more manners, one of which is the creditor's holding will represent a claim to a pro rata share of a sinking fund to be set up by the group, where future revenue of the group's post-restructuring proceeds and proceeds from disposals of investments will be deposited. Lastly, creditors will have a right to participate in decisions relating to the economics of the tokens via participation rights in a post-restructuring BRC subcommittee. That is the first part of the restructuring plan. There's a further part to the restructuring plan, which is that new money investors will invest approximately 47.5 million to the group. Your Honor will see that at paragraph 95 of first Yang Zhou. Your Honor, all my references will be to the 192 OA 192 affidavits. Further to the new money investments, there will be further contributions from Wang and from Young. And the reason for this is quite simple. As we have disclosed, essentially the consolidation of cryptocurrency of the whole group to the point where we now cannot tell which entity owns what. And we have also disclosed, for example, that under Wang's leadership, there was proprietary trading activities which were risky and not backstopped by the group's internal risk management. We have already anticipated that there may be potential claims against these individuals that creditors might allege or wish to pursue. So, Your Honor, to make this scheme work, especially if Young is going to be essentially attracting investors and coming up with this new go-forward business plan, there needs to be a third-party release against the directors of the group. And in exchange for that third-party release, they can't get away scot-free, Your Honor. There needs to be some contribution from them. Your Honor, the bottom line position to date is that of this contemplated new money investment, 22.75 million has already been raised. And signed term sheets have been entered into for 22.75 million. Your Honor, the third part of the plan essentially relates to a potential new business of the group, which we have described in the affidavits as being essentially the DeFi business. Essentially, this arises from, and Your Honor would have seen this in paragraph 87 of First Yang Zhou. At paragraph 87, we are starting at 86. Following the Chapter 11 filings by FTX in November 2022 and Genesis in January 2023, there were increasing concerns about the risk of intermediary failures in traditional CeFi operation models. Now, what happened after that is because of this and taking on feedback from the new money investors, the company had to adjust its go-forward business plan to pivot from its focus on a CeFi business model right now to a more DeFi-based business model in order to generate revenues. Now, how that DeFi business model differs from CeFi is that it removes intermediaries and it uses essentially automated applications developed on blockchain platforms to ensure transparency. So originally, after Yang had exited from the company in late 2021, he had wanted to do this project on his own. So at the time, he was developing this independently, and Your Honor can see that at paragraph 87. But seeing the shift in industry focus from CeFi to DeFi, and hoping to basically help creditors out, he had offered to leverage on his independent DeFi project to be the main driving force in the adjusted go-forward business plan of the group. So, Your Honor, that is hopefully a not overly detailed summary of the business plan going forward. We submit that this is sufficient already to satisfy the test of a intended compromise or arrangement for the court to find that this scheme is prima facie viable and feasible.
Well, Mr. Yeo, I'm not quite sure how the creditors will react to seeing an offer of what, 47.5 million coming in by the original directors when everyone's got a lot more at stake. So I don't know whether that's going to sway anyone, but aside from that, would you like to address me on the points raised by Mr. Burgess in relation to the breach of payment regulations?
Yes, Your Honor. So if I can turn to that straight away, that is at paragraph 91 of my submissions.
Mhm.
And essentially, Your Honor, the objection seems to be that the applicants were not registered as fund managers under the Securities and Futures Act and had offered financial services products which were not registered with MAS. Your Honor, at paragraph 92, we set out exactly why we disagree with these allegations. First of all, as Your Honor would have seen, there is no licensing requirement for the management of a fund that trades in digital payment tokens if it is offered to accredited and institutional investors only. That is an express exemption from the licensing requirements in the SFA. So that's the first point. Your Honor would see at paragraph 93, we also set out that the borrowing and lending of ETH, BTC, and USDT is not a regulated activity. And Your Honor would see a quote from a consultation paper issued by the MAS itself, which specifically states that not all types of cryptocurrency activity falls within MAS's regulatory ambit. For example, cryptocurrency staking and lending are not regulated by MAS. And under the Payment Services Act, here it says PS Act, the facilitation of DPT, crypto, borrowing and lending is currently not regulated nor subject to any regulatory requirements. And just for completeness, Your Honor, we have not just covered lending, we've also covered the offering of OTC or over-the-counter crypto derivatives. And Your Honor would see two quotes from MAS consultation papers or responses to feedback. I will start with the first. MAS has received queries from industry participants about whether payment token derivatives, like those referencing Bitcoin and Ether, fall within the regulatory scope of the SFA. And the MAS's response was at paragraph 3.7, MAS does not intend to include within the regulatory scope of the SFA payment token derivatives that are not offered by by an approved exchange. On the next page, Your Honor will see MAS does not regard it as necessary or appropriate at this point to scope all payment token derivatives within the regulatory scope. Payment token derivatives as a general asset class do not pose systemic risks to the financial system. Therefore, it is not critical to regulate payment token derivatives unless it is offered by an entity that is systemically important. Paragraph 3.9, the MAS considers that payment token derivatives as a general asset class are not suitable to be legitimized and accorded a regulatory status at this point in time. Your Honor, I can go through the second quote from MAS, but my submission is that this deals with the point already.
And you're able to say quite clearly that no regulatory action has been initiated by MAS against any of the applicants?
Correct. Yes.
Anywhere in the affidavits?
That was not in the affidavits, Your Honor. Part of the reason for this is that actually this whole issue of whether we needed to be regulated in the first place or whether there was a breach of regulatory requirements only was raised after the deadline for filing affidavits. So 3 or 4 days ago, Your Honor.
All right.
So if Your Honor wishes, I can file a further affidavit saying that, or I can get my clients to file that.
Yes, if you could do so, please. Thank
yes.
you.
So just so I record this down correctly, the affidavit should cover that there has been no regulatory action taken by MAS.
Yes, against any of the African companies.
Absolutely, Your Honor. Yes.
All right. Anything further, Mr. Yeo?
Yes, Your Honor. The last thing I wanted to cover was the substantial consolidation point. Substantive consolidation point.
Yes.
Your Honor, I am jumping a little bit back and forth, but this would be at paragraph 71 of my submissions. Your Honor would have seen, for full and frank disclosure, we had disclosed that following losses and by reason of the consolidated basis on which the group operated, we are not in a position to distinguish what remaining cash or crypto assets belong to which entities. And that the assets of the group are so intertwined that it would take vast expenditure and time, neither of which can be afforded, to identify which assets hold which crypto. Your Honor, we submit that this is no bar to proposing a feasible scheme of arrangement for any one of three reasons. First is substantive consolidation or pooling. Second is that we intend to propose a deed poll scheme. And third, just general ordinary law principles on commingled funds, which are consistent with how we intend to propose the scheme. I will cover the substantive consolidation point in greatest detail, and mostly because I suspect Your Honor is even more familiar than I on the others. So starting with paragraph 74, this is the BCCI number 3 case. I will highlight at the outset that this was a liquidation case. It was an application by a liquidator to pool the assets of two groups of company in liquidation by way of the liquidator's exercise of powers to make compromises or arrangements with creditors. Your Honor would note that that's a similar power to what we find in section 1441C of ERDA, that liquidators have powers to make compromises or arrangements. And essentially the holding, Your Honor, is what I have set out on the next page. As for pooling, the Vice Chancellor said of the pooling arrangements, I have in no doubt that the arrangements are so plainly for the benefit of creditors that I should approve them without further ado. I am satisfied that the affairs of BCCI SA and BCCI Overseas are so hopelessly intertwined that a pooling of their assets with a distribution enabling the likely dividend to be paid to both companies' creditors is the only sensible way to proceed. It would make no sense to spend vast sums of money and much time in trying to disentangle and unravel. And the Court of Appeal, when faced with the Vice Chancellor's decision, held, I entirely agree. I would reject the submission that there should first be further investigation as to whether pari passu distribution is the correct basis for pooling or not. In the complexities of the case, I do not see that further investigation would likely be fruitful, and the time taken would defeat the time limit of the contribution agreement in that case. Your Honor, BCCI number 3 has been cited by the Singapore Court of Appeal, but in relation to the contribution agreement, not necessarily the pooling order. That is paragraph 75 of my submissions. Now, a question may arise when faced with this BCCI case at paragraph 76 of my submissions. The question may arise, look, BCCI concerned the court's power to approve a liquidator's entry into a compromise or arrangement on a pooled basis. But it doesn't actually say something about a scheme. First of all, Your Honor, the court in BCCI number 3 expressly said that a scheme is the best way to do this, in fact. But a scheme was not possible in that case for other reasons. But second of all, Your Honor, at paragraph 77, I set out Australian courts who have expressly held that there's no doubt at all that such substantive consolidation or pooling may take place via scheme of arrangement. Now, it is notable that the same Australian decisions who say that there's no doubt at all that you can do it by a scheme take a narrower view of whether a liquidator could do so. So, if anything, they're more strict than BCCI. But even they have held that, yes, it is in principle possible for a scheme arrangement to do this. I should disclose at the outset that, again, all of these cases were cases relating to a liquidator's application for directions. So Your Honor can see that at the top of the next page for paragraph 77. So Dean Wilcock was a case where Young J held, again, in relation to a liquidator's application for directions to consolidate two liquidations, essentially. That assuming it's possible to have consolidation in corporate insolvency, how does one do it? There seem to be four main possibilities. First of all, there's no doubt that a scheme of arrangement could be approved by the creditors and the court on this pooling basis. And then he goes on to discuss other methods in the rest of the quotation on this page. And Your Honor, just to show Your Honor the narrower approach by the Australian courts, I'm at paragraph 78 now. where a discussion of Whittingham can be found, where the court essentially said, well, cited first of all another decision of young CJ by this time in Black Stump, where the court had held that one cannot just cite these earlier pooling arrangement cases as saying that the court has power to authorize a pooling of assets. It is quite clear to me that the court has no such power in the liquidation context, Your Honor. When a company goes into liquidation, the following consequences follow, and that's why pooling, just generally pooling in liquidation, should not work. But Your Honor can see the very next paragraph, paragraph 17, where the court says there's no authority on anybody other than where a scheme of arrangement permits a prescribed majority to override individual rights for rights to be altered. And then young CJ went on to refer to particular methods of how you can have pooling, right? And again, the very first option to give effect at the bottom of the page, Your Honor, the very first option to give effect to a pooling of or consolidation of the kind sought was a scheme of arrangement between each company and its creditors. Your Honor, the overall paragraph 79, this means even the narrower decisions of the Australian courts accept that a substantive consolidation or pooling order may be made by way of scheme arrangement. And I just want to describe to Your Honor the difference between BCCI and the Australian cases. What the Australian cases are essentially saying is that the liquidator's power to make a compromise or arrangement with its creditors has to be done on a per creditor basis. So if you want to make a compromise with creditors A, B, and C, you need to get the assent or consent of all three creditors A, B, and C before you are able to do substantive consolidation or pooling, right? In that case. So that is the narrower view that the Australian courts are taking, that the power of compromise for liquidators is not like a scheme arrangement where you get 75% approval and then you bind everybody, right? It is on this narrower basis that you're not proposing a scheme. So if you want to make a compromise with a creditor, you need to get the consent of that creditor. So that's the difference. But even then, the Australian courts have held that you can do substantive consolidation or pooling by way of a scheme arrangement. Paragraph 80 to 81 essentially set out the US and New Zealand position.
So don't need to go there. Yeah, don't need to go there.
Yes, understood, Your Honor. So just to apply this to the facts, Your Honor, at paragraph 82, Houlihan Lokey, the financial advisor of the group, have expressly opined that the assets of the group are so intertwined that it would take vast expenditure and time to essentially identify which entity owns what. And it is on this basis that we hope to propose a substantively consolidated scheme arrangement, Your Honor. Your Honor, I did say that I would not cover the deed poll or commingled funds authority for this, but I do wish to highlight one last thing, Your Honor.
All right.
I also see that I'm coming up to time. The one last thing is essentially my duty of full and frank disclosure. And that is at paragraph 90. I have already disclosed the essentially the commingling of assets by the group extensively already. So just to address the other things, first is the proprietary trading activities, which I referred Your Honor to. In December 2021, Wang procured Moon Alpha to establish two derived accounts which engage in proprietary trading activities. Now, what happened is the group maintained a risk reserve fund to hedge against trading losses and to safeguard against stop loss or hedging measures. But these proprietary trading activities were not safeguarded by those measures, in effect. In other words, those proprietary trading activities were not monitored or taken into account under the risk management calculations of the normal trading business. Now, since then, we have taken steps to hopefully strengthen the corporate governance of the group and remove Wang from the management and operations of the group. Also to make sure that he does not exercise his rights under the shareholders agreement and so forth. Now, I note that derived has raised criticism saying that all these corporate governance mechanisms essentially amount to is just removing Wang. I would respectfully disagree. That's precisely why Houlihan Lokey was engaged to be financial advisors to the group. The applicants had also offered to engage and had in fact already engaged FTI as independent financial advisors. And that is on affidavit. Now, since then, we've received proposals by derived, not from other creditors, but only derived, to appoint somebody else as a monitoring accountant. I think they have proposed Alvarez and Marcel. Your Honor, my client has expressly gone on affidavit to say that we are fine with whoever the court appoints. We had actually already engaged FTI to perform that role. I believe FTI is a reputable name and they will take their duties of independence very seriously. The only concern here is if Your Honor wishes to appoint somebody else, that is fine. But if there's any increased cost from the quote by Alvarez and Marcel, we had humbly asked Your Honor to consider that and ask for the creditor or creditors to bear that cost instead. Simply because the assets of the group are fairly limited and we don't know what Alvarez and Marcel's cost is in the first place. I don't know what basis on which they've proposed to be engaged. So we have provided for and provisioned for FTI to be appointed. We have a certain set of funds set aside for that. But if Alvarez and Marcel is significantly more expensive than that, we hope not to prejudice other creditors of the group.
All right. Anything else, Mr. Yeo?
Yes, Your Honor. We had paragraph 90 has a number of other disclosures. Perhaps I'll just go through one. We had received a number of statutory demands and been subject to certain proceedings since June 2022, but we had managed to do without a moratorium since then. So just to disclose to Your Honor that for a while it looked okay, but unfortunately, by now it does appear that a moratorium is required. Most notably the proceedings the proceedings I've been notified about just today by derived.
All right.
If there's any other way that my clients can assist, hopefully Your Honor would have seen that we are coming to court on a very transparent basis, that we have disclosed, I think the US term is open the kimono, that we have been transparent, but we are ready to assist Your Honor in any other way that is needed.
All right, thank you. Mr. Verghese, before I come to you, let's take a short 5-minute break. All right, we'll then adjourn. Annie?
What is adjourned? We will resume the hearing now.
Yes, sorry, yes, Mr. Verghese, thank you.
Grateful, Your Honor. Your Honor, just by way of the lay of the land, I'm just going to first address the court on our objections to the application. Going to be with 3 main points. First is the non-compliance with the conditions under Section 64 of the IRDA. And then I'll address the court quickly on the fact that Moon Alpha in particular is not suitable to be added to this proposal on grounds of the COMI not being in Singapore, and that Moon Alpha has no substantial connection to Singapore. And then finally, I'm going to address the court on the question of lack of bona fides. After that, Your Honor, I will also address the court, if the court is minded, nevertheless, to proceed with the order, what our alternative submissions are on that front.
All right, yes.
So on the question of non-compliance with Section 64 of the IRDA, Your Honor is of course familiar that under Section 64, subsection 4, there is a mandatory obligation on the part of the company to file with the court and the application evidence in support from company's creditors, which importantly includes an explanation on how such support would be important for the success of the intended or proposed compromise or arrangement.
Mm-hmm.
The other point is they are also mandated to disclose the list of all unsecured creditors who are not related to the companies or the top 20.
Mm-hmm.
Now, the duty of full and frank disclosure, I would refer the court to paragraph 12 of our written submissions, where we refer to the report of the Committee to Strengthen Singapore as an International Center for Debt Restructuring, dated April 2016.
Mm-hmm.
And there it makes the point that the purpose of requiring disclosure of this nature is to safeguard against abuse. And therefore, the committee recommended the basic information be provided, and that specifically the committee held, absent any such information, or where there is a failure to give full and frank disclosure of material matters, creditors and other interested parties may apply to court to lift the automatic moratorium.
Mm-hmm.
Now, Your Honor, the additional point I make is at paragraph 13 of our written submissions, we also refer to the fact that an application brought under Section 64 must be brought in good faith, and that a lack of particularity of the proposed restructuring plan is an indicium of the absence of bona fides, and the applicant must give cogent and reasonable explanation for the lack of particularity. So against that setting, if we now look at the evidence that's been put forward, first beginning with the letter of support, if I may please turn Your Honor's attention to the bundle of documents, volume 1, at page 335. That's bundle pagination 335, Your Honor.
Mm-hmm.
The in bold to the right extreme. There, Your Honor will see, by way of example, the letter of support that has been tendered. Now, Your Honor will firstly see that the name of the supporting creditor is redacted. But in addition, the letter does not actually speak to the size of the debt that is held by this particular creditor. And therefore, Your Honor, there is no sense when one reads this letter of support, what is the quality of this creditor? What is the significance of this creditor? It's unknown. And this is important, Your Honor, because there is obviously a distinction between creditors like customers who may be owed a lot of money, but are really not going to be able to help or contribute in the successful carrying out of the restructuring plan, as compared to significant creditors who actually can play a part and a critical role in ensuring the success of any proposal to restructure debts. And to give Your Honor an idea of who might those critical creditors be in the context of Babel, if I could please turn your attention to to volume 4 of my bundle of documents. Your Honor will see at page 144, that's PDF 44, and I think it's printed page 44 as well, Your Honor.
All right.
Here is a presentation deck put out by Babel. And if I can please draw your attention to the column rightmost, you will see a reference to selected partners. And there, Your Honor, will...
Sorry, Mr. Burgess, this is page 44.
144, Your Honor.
144. Hold on a moment.
Yeah.
All right, so yes, carry on, please.
Right. Just to ensure that we're on the same page, because I'm noticing now that there are 3 pages set out. It may well be 140, which would be the page at the bottom right of the...
Yes, I got that. Thank you.
So here is a presentation deck put forward by Babel. And if you could please look at the rightmost column under selected partners, Your Honor will get a sense from that the kind of creditors who we would say are potentially significant creditors. So firstly, you see the example of 100+ exchanges or trading firms, which our client counts as one. And you will see derived in the middle of that selection. You have not so much wallets or custodians, but if you then move on to the bottom of that page, there's a reference to lending desks. And you will see references to companies like Genesis and so on and so forth.
Right.
So it's important when one considers these letters of support to have an appreciation of who exactly are these creditors so that the court can make an assessment on the quality of the creditors. Now, it may be said that, well, the information is redacted only vis-a-vis the creditors, but not vis-a-vis the court, so the court has full optics. However, that misses the point with respect, because the court will, in ordinary circumstances, look to creditors and non-parties who are involved in the case for some directions or some guidance as to the significance of particular parties. The court will need that context, that background, that information, which is invaluable to appreciating the significance of these names, because otherwise, with respect, Your Honor, these are all just names to the court. And so to say that, look, as long as I've filed this, albeit in redacted form, the court has full visibility on it, I fulfilled the statutory requirement, we say with respect is misconceived. Likewise, Your Honor, in respect of the top 20 creditors, for that, if I can please turn your attention to volume 1 of the bundle of documents at bundle pagination 713, volume 1, page 713.
Yeah.
Here they've listed out the top 20 creditors for Moon Alpha, which is the specific applicant that we are interested in. And Your Honor will see in this case, for example, there really is only one creditor with a very sizable debt of 620 million. You can see that in second place, the ID gives it away DRB. That is, in fact, I believe, a reference to our clients coming in second at 12.5 million. Now, and so when my learned friend talks about sensitivity and all of that, really, as I look at it, the one creditor that matters is the first, because if you put that aside, we are in fact the largest creditor for Moon Alpha, right? And certainly in respect of that creditor, without knowing who this creditor is, without being able to have some understanding what is the nature of the debt, there's really no way that we can make any submissions to the court as to, number one, the veracity of the claimed debt amount, the basis of this claim amount, or the significance of this particular creditor. And in the scheme of things, is this really just a trade customer, or is this a creditor that can actually play a much more significant role in the carrying out of any proposal being put forward? Now, this question of getting information out to the creditors is something which has been dealt with in a slightly different context in the TT International case. For that, if I can please refer you, Your Honor, to the non-parties bundle of authorities. at page 374, that is tab 20. Bundle pagination, and I'm at paragraph 94 and 95. I should preface by saying that this discussion is in the context of voting. And with that, if Your Honor turns with me to paragraph 94, it says it's common practice for chairman to post a list of the scheme creditors and corresponding amounts of the admitted claims for the purposes of voting at the meeting venue before the creditors meeting. And then skipping to paragraph 95, it says this practice is sound as it safeguards the integrity of the voting outcome. Creditors commence voting knowing how much their votes will count with or against those of fellow creditors. And this is the critical bit, Your Honor. In addition, the information allows some measure of informed consultation between the creditors regarding the exercise of their votes, and that this is likely to lead to a more considered and informed vote by the body of creditors as a whole. And if we were to juxtapose that reasoning or rationale to our situation, Your Honor, we say it applies with equal force, that in considering whether or not to consent to or object to a moratorium application, in considering the question of any proposal that's being put forward, the viability of that or the acceptability of that, it would be important and beneficial for the creditors to know who the other creditors are. So now moving on quickly, let me now address the applicant's reasons for non-disclosure. And I submit, Your Honor, that these reasons are not, in the final analysis, cogent. The first reason given is that it's okay to redact this information because there's no prejudice to the creditors. And our short answer to that, which is addressed at paragraph 26 of our written submissions, is that we would be denied the opportunity to, firstly, consult with other creditors on how creditor interest can be protected. Secondly, to discuss the appropriate steps regarding the moratoria application. And thirdly, we are being denied the opportunity to give evidence, make submissions on the veracity and quality of the purported creditor support. And then, of course, we go on to make the point I just made about how, apart from the 620 million creditor, we are in fact the largest creditor as far as Moon Alpha is concerned. Now, the second point raised by my learned friend is this: commercial sensitivity.
Yes, sorry, Mr. Burgess. Sorry to interrupt you, but I think some of these points really would have been canvassed in relation to the sealing application. So insofar as they overlap to that extent, I don't think you need to traverse them again. I've taken note of your submissions and arguments here. Perhaps it would be more useful to focus on the other points raised.
Yes, yes. So yeah, I actually didn't raise these issues in my comments on the sealing application, but anyway, submissions are all there, Your Honor.
Yes.
Other submissions on commercial sensitivity, contingent effect, and non-disclosure is at paragraphs 26 to 28 of our written submissions, and I'm happy to leave it at that.
All right, thank you. I'll take note of those arguments. Thank you.
Yes. The other point I'd like to make, and I think this is a fairly obvious point, Your Honor, is that in IM Skaugen, the point is made on the quality of the support from the creditors. And in particular, if Your Honor would like the reference, it's at paragraph 58 of the IM Skaugen decision. The point is made If significant or crucial creditors were supportive, this is a material consideration, and that explains why the requirement for the applicants to list all creditors and the 20 largest so that the court can properly weigh the support and explanation of the importance of the support. Now, this leads me to my next point, Your Honor, which is under Section 64, for subsection A of the IRDA, the applicant is mandated to offer an explanation on why the support would be important for the success of the intended or proposed compromise or arrangement. Now, when we then look at Mr. Young's first affidavit in OA 192, and here, if I can please refer you to paragraph 147 of his affidavit, which is found at volume 1 of my bundle of documents, volume 1 of my bundle of documents, at bundle pagination 71. At paragraph 147, this is all that Mr. Young has to say. He says the significance of creditor support for the restructuring in advance of any scheme application being filed, and even in advance of the moratorium application herein being filed, adds material certainty of implementation of the scheme, which cannot be understated. In other words, Honor, he's given absolutely no meaningful explanation as to what support means in these circumstances. And quite frankly, because they've decided to redact that information and make no references to the identity of the relevant supporters, one can immediately say that it's not going to be possible to meaningfully address or explain how these particular supporting creditors are significant. So the failure to give a proper explanation on the importance of whatever support they've obtained, we say, Your Honor, has to be held against them. The failure to disclose the identity of the creditors has deprived my client's DRV from making any submissions on the quality of the support. And so if one goes back to the statutory purposes, we say that the statutory purpose is entirely lost on the manner in which they have chosen to proceed with this application. That's that in respect of my first point. I now move on to the second point, which is concerning Moon Alpha in particular. So I'm just zeroing it on Moon Alpha to say ultimately, Your Honor, that even if Your Honor was minded to allow a moratorium with a view to this group restructuring, that Moon Alpha should be set out and set apart from that exercise. My reasons are this. Firstly, Moon Alpha, contrary to what has been suggested, is in fact just not part of the Babel group of companies. Whether one looks at it legally or one looks at it financially, they're simply not part of the Babel group of companies. Now, what Mr. Young has done in his affidavit is sort of tried to suggest to Your Honor that somehow the Moon Alpha is financially integrated into the Babel group. And for this, if I can please take you immediately to Mr. Young's first affidavit, and in particular, can I take you to volume 1 of the BOD, bundle pagination 36. And I'm just going to refer Your Honor to 2 paragraphs before I make the point on how slippery the presentation of the facts is in this case. So if we look at paragraph 67, it says the group's management accounts are prepared on a consolidated basis by consolidating the assets, profits, and losses of the group, including Moon Alpha. And then it goes on to say Moon Alpha consolidates its profit, loss, asset, liabilities with the group. And then if your honor goes with me to paragraph 74, they go on to say, despite the fact that the group has been preparing its financial records on a consolidated basis so as to better reflect its cryptocurrency. So I just ask your honor to please note that the suggestion is the group has been preparing financial records on a consolidated basis. And as we saw from 67, the reference to the group here includes Moon Alpha. Then they go on to say each debtor company still maintains standalone financial statements to fulfill statutory requirements. Nothing remarkable there. However, if we then go on to the next sentence, it goes on to say these standalone accounts are prepared on the basis that the pooled asset of the entire group will be shared on a pari passu basis amongst debtor companies, pro rata in accordance with the net external liabilities of the debtor companies owed to customers. So I'm not exactly certain what this sentence means. Is this a sentence referring to the historical fact of how the consolidated accounts of the group is prepared? Or is this really a statement of how they propose to deal with any compromise or arrangement that they are putting forward? It's not clear. But what is clear, Your Honor, is they then refer to each debtor company's respective balance sheet, and that can be found at page 293 of the same bundle. If you go to 293, as was adverted to at paragraph 74, what you see is, in this instance, the company accounts of Babel Holdings, their balance sheet apparently. And then in the following pages, you will see the individual company balance sheets for the other applicants. What you do not see, Your Honor, is any documents supporting the suggestion that the company's financials have been consolidated to include Moon Alpha's accounts. And I say, Your Honor, with respect, it would be hard to imagine in what accounting terms there would be a company consolidated accounts or group consolidated accounts of all these companies, including Moon Alpha, when Moon Alpha is in fact not a subsidiary or related company. So from an accounting perspective, I'm not sure what Mr. Young means, but what is significant is that if in fact Moon Alpha is financially integrated into the group such that even their financial statements are consolidated, it would have been a very simple matter of disclosing the group financial consolidated accounts. And that hasn't happened. Instead, all you are shown under the guise of full and frank disclosure is nothing more than the balance sheet of each individual company. And then when we look at Moon Alpha's balance sheet, Your Honor, at page 295, what jumps out of the page for me when I looked at it is the fact that Moon Alpha's financial balance sheet, looking at the third row from the bottom, for some reason, the share capital of the company is listed as 0. And it's a very peculiar situation, Your Honor, that the share capital of a company that has assets totaling 505 million and liabilities totaling 695 million, that apparently this company has 0 in terms of issued or paid up share capital. And of course, this is the only accounts that the court has shown. And of course, this is presumably on the basis that Messrs. Loki and FTI have all gone through this and have verified these accounts. So this is the state of play as far as the evidence that the court is being shown. Now, so that's to wrap up, Your Honor. The point that we are making is, insofar as the allegation is that Moon Alpha is part of the Babel Group, when one actually takes a closer look at the evidence on the consolidation of the accounts, there's just nothing there. Now, the next point we make is, Your Honor is aware in ZIP Max at paragraph 15, the court made the point that determination of COMI depends on what COMI factors are objectively ascertainable by potential creditors, and that is a material consideration. The court would also look to what weight would creditors give to a particular COMI factor. Does Your Honor need me to take you to that particular reference? Yeah. And therefore, looking at the evidence through those lenses, Your Honor, i.e., what this would have appeared to creditors at the time they were transacting with Moon Alpha, starting point of any COMI assessment is place of incorporation. And here we know that Moon Alpha is a Hong Kong incorporated company. Secondly, Young is the only director of Moon Alpha. And in his affidavit, he claims to be a resident of Singapore. Now, to be fair, my learned friend has disclosed the employment pass issued to Mr. Young by another employer, which is BAAM, Babel Asia Asset Management. And so we know that he has immigration status in Singapore, right? Albeit with a different employer. But we know that he has immigration status in Singapore. The point I'd like to draw to the court's attention is if we look at the very recent ACRA filing by Moon Alpha, Your Honor knows, despite the suggestion that Moon Alpha has been actively trading in Singapore, it was only on the 23rd of February 2023, just a month ago, that they have registered Moon Alpha as a branch of a foreign company in Singapore. And if I can now take you to the relevant ACRA extract that's found in volume 2 of my bundle of documents, volume 2 at bundle pagination 619.
Yes, Mr. Verghese.
Yes, volume 2 at bundle pagination 619, Your Honor. This is the non-parties bundle of documents.
Yes. Please carry on.
Yes. So if Your Honor looks at volume 2, bundle pagination 619, this is the extract of the ACRA as at 23rd of February 2023. Your Honor will see that Mr. Yang Tso is listed as the director of Moon Alpha Financial Services Singapore branch. And under address, you will see that he has listed himself down as residing in Hong Kong. And secondly, you will see that they have one Miss Lo Siu Yi listed as authorized representative, and she is residing in Singapore. Your Honor, the fact that the Singapore branch had to enlist Ms. Lo's assistance to be the authorized representative in Singapore suggests to me that this is because she's the one who's residing in Singapore. And it implies that he is a non-resident director. So the point I make is a simple one. The fact that Mr. Yang Tso is listed as a director, or that he has immigration status in Singapore through another company, at best, Your Honor, is a neutral factor. Next, DRB, in all its dealing with Moon Alpha, was only ever dealing with Moon Alpha. DRB had no dealing with Babel Finance, no dealing with Babel Group, no dealing with Babel Asia Asset Management, or Shinar. It always and only dealt with Moon Alpha. And in this regard, Your Honor, I think it's important to show Your Honor the KYC documentation provided by Moon Alpha given to DRB. That's found at volume 3 of the bundle of documents, volume 3, at bundle page 101. And there, Your Honor will see Mr. Yang Tso again, under the question of where his usual residential address is, he lists himself down as living or having his usual address at Dali City in Yunnan province. And so this is entirely consistent with the fact that Moon Alpha Financial Services is also listed with its jurisdiction as being in Hong Kong. And so from the perspective of a creditor who's done its due diligence, the picture that comes across is that they're dealing with a Hong Kong company and that the director is usually residing in Hong Kong. And then if you turn to page 102, just the following page, Your Honor will see a couple of shareholders listed. Ms. Well, I shouldn't assume. Yi Lingzi is said to be living in Jiangsu province in China. Ji Chengcai in Shanxi province, China. Yang Tso himself in Dali City. And on page 104, Your Honor will see another shareholder is Moon Alpha Holdings, which is situated at the British Virgin Islands. So again, absolutely nothing to indicate any connection with Singapore. Next point, the agreements between Moon Alpha and DRB, all agreements between Moon Alpha and DRB have Dutch law as their governing law, and stipulates the Amsterdam courts as having jurisdiction. Next, when it comes to Moon Alpha's crypto lending business, which it does with its own customers, all of those agreements are governed by Hong Kong law. And again, with respect, we say that potential creditors would give weight to this fact that these are all Hong Kong law governed contracts. Now, in contrast, the applicants seek to establish jurisdiction by making the point that Yang is resident in Singapore. I've dealt with that. But I also highlight, Your Honor, for what it's worth, the affidavit he filed in support of the application dated 6 March, even that was signed in Palo Alto, not in Singapore. Next, the applicants assert that Moon Alpha has clients and creditors in Singapore. And with respect, we say this is not a material factor because on their own case, Moon Alpha's crypto lending business was open to customers from all over the world, and that these agreements were governed by Hong Kong law. So the mere fact that they may have had some customers living in Singapore is really adding nothing to the analysis. Next, they argue that Moon Alpha was in fact carrying on business in Singapore through employees working in BAAM's office in Singapore. That's Babel Asia Asset Management. And again, our response, Your Honor, is that this is merely a bare assertion with no details as to whether any of these employees were Moon Alpha employees. In fact, I think it would be fair to say on their own case that this Babel Finance team, as they call it, must be employees of some other Babel entity. Because I think if the point being made is these were engaged or employed directly by Moon Alpha, I don't think they would be remiss to highlight that, not to highlight that. But the other point of significance is this, and if I can please ask Your Honor to turn with me to Mr. Young's first affidavit, volume 2 of the bundle of documents, page 588. Your Honor, that's our bundle of documents, volume 2, at bundle pagination 588.
Yes.
So here, Mr. Young gives us some insight into the history of Moon Alpha. And paragraphs 15 and 16, we say, are quite crucial, because he says, prior to establishing BHL and the other Babel Group companies, it was Moon Alpha, the company that is being used to conduct business, including launching an online crypto lending platform private and providing credit facility services to registered users. And this is the key, Your Honor, until 1st July 2021. And then it says, while the company is not directly or indirectly owned by BHL, it continues to operate its business under the name Babel Finance brand name and has maintained important client relationships, as well as a series of long-term strategic relationships with key market players for the past several years. And then it goes on to say mobile application continues to be operated by the company in respect of crypto lending and asset management transactions until the user agreement for the private application were updated on 1st July 2021, after which contracting parties became BBL instead of the company, and that the company also maintained cryptocurrency trading accounts with DRB, not particularly relevant. The point I'm making is, it seems that the business that Moon Alpha was conducting was effectively novated to BBL from July 2021. And apart from the reference to doing business with our clients, Your Honor has heard about the proprietary trading that was done with our clients. Apart from that, there's really no indication of what other business Moon Alpha has been involved in since July 2021. And so I would invite my learned friend, when he comes on to reply, to confirm whether or not Moon Alpha has effectively ceased business since July 2021. Now, the other point that is being made belatedly is that Moon Alpha is now registered in Singapore as a foreign company. And Your Honor, we say this was done on the 23rd of February last month, less than 2 weeks before they filed these applications. Again, it's quite clear that these are all nothing more than posturing on the part of Moon Alpha. And clearly, for the purposes of Comey analysis, this is precisely what the courts are careful to look out for. And that's why the test has always been what creditors, when dealing with Moon Alpha previously, would have known and understood, not so much what they do 2 weeks before filing an application for moratorium.
All right, thank you. Mr. Verghese, we're coming up to 20 minutes to 5. I'd be grateful if you try to wrap up by 5, please, for all your points.
Yes, yes.
Right.
The next point that they make is that the crypto assets are in Singapore because the private keys are controlled by individuals in Moon Alpha's management. Now, here, Your Honor, our response is, on their own case, the crypto assets are owned by the corporate entities, not by individual employees in the management of Babel Finance who happen to be holding the private key. Private keys, it's not actually a physical key, Your Honor knows, it is a code. And that code can be duplicated. 10 of us can have the key. And the question of whether or not in that situation, who the owner is, I think the bottom line point I make is this, that when you look at the Dicey and Morris extract that was referred to, and if Your Honor wishes to look at it, it's at page 17 of Babel's written submissions. Firstly, you can see that even in Dicey and Morris, it says the law is still evolving, it's still very much in its infancy. When it talks about the question of lex situs rules, significantly it says, it may tentatively be suggested that a solution based on owner's location is the best fit. In other words, it implies that the law is far from resolved on this issue. Your Honor also knows cases like Osborne, which is referred to. These are all ex parte cases. They've not actually been determined or settled in any meaningful way, either in England or in Singapore. But the most important part is this. If you go to the bottom of that extract, it says the owner is generally understood to refer to the party in possession of the private encryption key, giving access to cryptocurrency. And my submission to Your Honor is this, properly understood, especially when you look at on the back of the cases referred to, that these are all cases where the owner were individuals. And so when you're talking about an individual being the owner, then you say the person holding the password is the owner. That's one thing. But now the question facing the court is, my learned friend is now suggesting that despite the fact that these assets on their own case are held by corporations, the owner happens to be the individual working for the company. And if that individual is cited in Singapore, then therefore the lex situs in Singapore. And we say that can't be the correct approach. Your Honor has also addressed the question of lex situs in ZipMax. For shortness of time, Your Honor, I'll just give you the reference. It's found at page 319 of my bundle of authorities. And at paragraphs 22 and 23, Your Honor deals with the question of lex situs, determining in that case not to determine the lex situs of the assets. Your Honor was not even prepared to assume that the assets even have a lex situs. and that the resolution of the precise nature of cryptocurrencies in insolvency case in Singapore is left for another day. And Your Honor, I would say respectfully that this is actually quite an involved question, and it may not be a suitable matter to be decided in the course of a moratorium application. And in other words, this is not an issue that the court should put much weight to, given the evolving nature of this area of the law. Lastly, Your Honor, I move on to the lack of bona fides. The point is made in Skaugen at paragraph 69, which can be found at page 211 of my bundle of authorities. The point is made that applications for moratoriums should be brought in good faith, even if the good faith requirement is silent as far as the statute is concerned. There's no question that there is a bona fide requirement. Secondly, at paragraph 70, the bona fide assessment is ultimately a multifactorial assessment based on the particular context of the case. And there's a reference to US authorities, which refers to the applicant needing to have an honest intent and genuine desire to use the statutory process to effect a plan of reorganization, as opposed to using the application to hold the debtor in its present status for the purposes of restraining, delaying, and hindering creditors and to escape from proceedings in other courts. So on the question of bona fides, Your Honor, and one takes a step back to look at what has happened. As Your Honor knows, the group had appointed Polian Loki as early as July 2022. The slides put forward by Messrs. Loki suggest that Kirkland Ellis were also appointed in around July 2022. And after that, what has happened is they produced two decks, one in August and one in October 2022. If Your Honor requires the references to that, it's found in volume 1 at page 299 and in volume 2 at page 136. And these slides, Your Honor, were only circulated to a select group of creditors in November 2022. The slides were not shown to DRV because DRV did not sign the NDA and a standstill agreement that they were requiring us to sign. So therefore, despite being the second largest creditor of Moon Alpha, we were not engaged on any plans or proposals simply because we were refusing to sign a standstill agreement. As far as the standstill agreement is concerned, they were initially asking for a standstill until 31st December 2022. We had told them that that's too long and we tried to negotiate for a shorter period, but thereafter we did not hear back from them. So in the round, we have not been consulted on this. And as far as the other creditors are concerned, all I would say, Your Honor, is apart from putting out the second deck in October 2022, apart from that, there's precious little in terms of insights as to what they've managed to do in the interim. What is significant, and my learned friend has alluded to this, is that up till now, despite engaging with creditors, they've only managed to muster 0.8% support in terms of value of the overall creditor group, as far as Moon Alpha is concerned. So nothing has happened in the last 9 months. Although they've got Messrs. Loki and Kirkland and FTI involved in this, what is significant, Your Honor, is that none of these professionals have actually filed an affidavit in support of the application. The only affidavit comes from Mr. Young. We have nothing from the relevant professionals and the accountants on this issue. So that's also something that the court would consider. Finally, the timing of the applications, they were filed on 6 March, which is exactly 1 week after the Hong Kong statutory declaration, statutory demands filed by my clients would have fallen due. And again, the timing is something that's quite significant. Now, it's also significant, Your Honor, that there was improper inclusions of related party creditors in the top 20 list and in the letters of support. In Mr. Young's second affidavit, it is significant that he alleged that Holy Hand Loki had confirmed that none of the creditors on the list were related, but then later changed his evidence on this. Now, the last point we make, Your Honor, is that Mr. Young knew that Babel Finance's business activities in Singapore required a license from MAS. He claims they were in the process of applying for one, but no evidence of any application has been put forward. And today we hear that they take the view that, in fact, they're not required to seek a license at all. And on this question, Your Honor, again, because of the shortness of time, let me just very quickly touch on this. If Your Honor were to look at Mr. Mark Tan's second affidavit, filed in OA 130, or OC 130, and that's found in volume 4 of my bundle at page 138.
Yeah.
Yeah. It is a slide titled Transform the Financial Infrastructure. Does Your Honor have the same page?
Oh, sorry. Which number are you looking at? The right hand?
There's one reference to a number in white, 142, and there's a reference to a number in red, 88.
I don't have color. Hold on a moment.
Your Honor's is not colored.
142. So is it the top right hand corner?
The page before should be the separation page, tab 11.
Tab 11. Volume 4 of your bundle of documents?
Yes.
I have your bundle of documents as volume 4 starting at tab 15.
Tab 15.
Yes. Tab 11. Okay, Mr. Mark Jing Wen should be tab 15, second affidavit of Mr. Mark Tan, correct?
Yes. So what's the bundle designation?
Never mind, hold on. Let me just use the alert copy. What was the date of his affidavit?
It's in actually volume 4 of the bundle, and it's in another suit, Your Honor. So
OC 130. All right, so we're OC 130.
Yes.
All right, I'm on OC 130. What date is his affidavit?
17 August 2022.
17th August 2022. All right, I've got that. Hold on a moment. Let me bring it up. All right, and this is on page 14.
It's tab 11 at page 138.
138. All right. All right, I've got that. All right.
Yeah, transform the financial infrastructure. Your Honor will see
all right.
A bulb on the right side, which refers to how they provide prime brokerage services.
Yeah.
And then if Your Honor were to go to page 99 of the same
Mm-hmm.
This is 99. Yeah. Your Honor will see in the darker section at the bottom half that there's a reference to crypto prime services. So Moon Alpha was providing crypto prime services, which in a nutshell, Your Honor, is to help their customers buy and sell crypto assets by acting as a broker, connecting multiple trading platforms to their customers. And we say, Your Honor, that on a proper understanding of the Payment of Services Act, this is definitely caught. And if Your Honor were to look with me to the bundle of authorities.
Hold on, sorry. Sorry, hold on, Mr. Burgess. So page, the problem is I'm not sure which number you're referring me to. I've got numbers in black and red. I'm not sure what else. Page 99 in the top right-hand corner or bottom right-hand corner?
Page 9, top right.
Page.
It says 99, and beside it, you have a 45 in red.
Hold on.
So if it's at top right, 99.
Hold on. I'm trying to look right. All right, page 99. I have page 149 at the bottom right, and you're referring me to what part of the page for the bit about crypto prime services?
Is there a black section on the page?
There's a black table.
Yes. So if you just look at the column on the left,
yes,
the title institutions.
No, I don't have institution. The slide title is directional shark fin. Is that what you want me to look at?
Yeah. Would you like to look at page 95, perhaps?
All right, don't
refer
me to one page because I'm getting very confused with the different pages on the deck. So I don't know which one you want me to look at.
Yeah.
Right, so 95 appears to be part 03, correct?
Part 03.
Sorry, Mr. Burgess, can I be clear? Are you asking me to look at the top right-hand corner numbering, top left-hand corner, or bottom right-hand corner numbering?
So on the top right-hand corner,
in red.
If your copy is in red, Your Honor,
yes, this one.
It says 45.
Sorry, it says 45. Oh gosh.
In red, yes.
Hold on. I don't know what I'm. Right, all right, finally found it. Right, page 45 in red. All right, hold on a moment. Crypto prime services. All right, carry on, Mr. Burgess.
Yeah, so the simple point is this is actually from their website, which if you click on it, it goes into the prime services offering. And the short point we make, Your Honor, is if you then look at the Payment of Services Act at page 25 of our bundle of authority.
My apologies, I don't mean to interrupt, but in your bundle numbering, in volume 4 at the top right, what page would it be? Because I will confess that I am lost.
All right, page 45 on the top right-hand corner in red. You have that, Mr. Loh? Sorry, Mr. It's 45, there's 49 in blue, and at the bottom of the page is 95 in black.
If you're looking at the soft copy, it's PDF page 99.
Page 99.
I don't think that's going to help, Mr. Burgess. Have you got that, Mr.
Page 99. Right. Okay. I believe we have found it. Is it the page which starts with 18 November 2018, Babel Bank received angel investment from...
That's right. That's right. He's referring to the contents below. All right. All
right. I understood. Thank you. My apologies, Your Honor.
All right. Sorry, Mr. Burgess, you were on to the Payment Services Act. Yes.
Yeah, so the short point is, if one looks at the Payment Services Act found at page 25 of my bundle of authorities, under section 5(1), it refers to a person must not carry on business or providing any type of payment services unless he has a license for that type of payment service or he is exempt. And then, if Your Honor goes to page 26, under the first schedule, part 1, services that are payment services include at 1F, digital payment token service. And digital payment token service, Your Honor, is defined at page 30 as any service of dealing in digital payment tokens. And if Your Honor is interested to know what dealing in means, that definition is found at page 29, which is dealing in payment token means buying or selling of digital payment tokens in exchange for any money or any other digital payment token. So buying and selling. Now, when you then look at the submissions put forward by my learned friend, very quickly, if I can please refer you to my learned friend's submissions at page 37 and paragraph 94. Here, whatever my learned friend refers to concerning the offering of OTC derivatives, we say, Your Honor, it's entirely irrelevant because that's not the basis on which we've raised the question of illegality. We're not suggesting that this is that they were involved in derivatives.
Isn't this though something for MAS to pursue?
I'm sorry, Your Honor.
Isn't this something for MAS to pursue?
Yes, it is.
So they've not pursued, as far as I can tell.
Yes, I'm not sure if they are aware of the situation, but yes, we don't seem to have any idea if they've pursued. Secondly, at paragraph 93, he talks about how there is no regulation on borrowing or lending of digital payment tokens. Again, our focus is not on borrowing or lending, but it's the fact that they offer prime brokerage services, which is buying or selling of DPTs or assisting in that. Finally, at paragraph 92, he makes the point that digital services offered to accredited and institutional services is exempt under the SFA. And my short response is, there's in fact no evidence put forward that the services provided by Moon Alpha was restricted to just accredited and institutional investors. And secondly, the last sentence of paragraph 92, he says, where funds buy and sell DPT, this is incidental to fund management activity and hence exempt from licensing requirements under the PS Act. So he starts with SFA and ends with PS Act. And with respect, there's nothing in the PS Act to suggest that the exemption under the SFA for accredited and institutional investors will relate to an exemption from licensing requirements under the PS Act. It's a non sequitur, right? So on this basis, we say, Your Honor, that there is reasonable grounds to believe that they were carrying out unlicensed trading, prime brokerage activities in Singapore, which amounts to buying and selling of tokens by connecting their customers with multiple platforms. So those are my submissions in respect of our opposition to the application.
You had the alternative ground, yes?
Yes, just 1 minute on what the alternative is.
Yes.
Your Honor, we say firstly that 6 months moratorium is way too long. We would say as a starting point to consider Your Honor's decision to grant 3 months in ZipMax, which was the extension after the expiry of the automatic moratorium period.
Yes.
In fact, we would say, with respect, that given that they've had already effectively 9 months to work on this with the very same professional advisors, Messrs. Loki and FTI, advising them for the last 9 months, we say, in fact, 6 to 8 weeks would be sufficient period for the moratorium after the automatic moratorium period expires next week, I think on the 6th of April. Secondly, Your Honor, we are asking for, in any event, we are asking for monthly disclosures. Thirdly, we are asking for monitoring accountant to update all the creditors. I hear what my learned friend says about FTI. Your Honor, I take no quibble with FTI at all in terms of their standing as professional advisors. The point we make, however, is that given that the whole purpose of the monitoring accountant is to benefit the creditors, to have FTI, who are already engaged by the founders and who are already actively working on this, it would make sense in the scheme of things to have the monitoring account being somebody else who can look with a fresh pair of eyes whatever is being put forward by FTI together with Messrs. Loki, right? Now, then on the question of the cost of Alvarez Marsal, or as my learned friend puts it, the additional cost of Alvarez Marsal above and beyond whatever they may have provision for FTI, Your Honor, with respect, having regard to the fact that the founders have been, on their own admission, guilty of unauthorized proprietary trading that has apparently caused a lot of the problems we are facing now, and the fact that the founders have been co-mingling these crypto assets, totally in breach of the separateness of each legal entity, again, on their own case, any cost occasioned by having to have a monitoring accountant should be visited on the company, right? And so those are the key points we wish to make. Finally, in respect of prayer 3 in the application, which is the worldwide moratorium application, Your Honor, we are asking for a carve out. Your Honor heard that my clients have just instituted Dutch proceedings against Moon Alpha. And the reason why we had to do this is because when we served on them the statutory demand in Hong Kong, they turned around to say for the first time that the debts are being disputed. They also pointed out that this debts should be ascertained by the Dutch courts as per the agreement. So we are effectively doing what they've asked us to do. which is to have this issue of our debts be adjudicated on by the relevant courts under the contract. And there is no prejudice to them to have this issue determined. I think our clients are determined to have this issue decided as soon as possible. And no doubt, visibility on what the appropriate debt value or levels are would be helpful if and when a scheme proposal is put up. So that's essentially my submissions, Your Honor.
Thank you. All right, Mr. Yo.
Your Honor, I will try to keep it quick. There were essentially three grounds of opposition. First, on Section 64, ADA non-compliance. Second, on substantial connection. And three, on bona fides. Then there was essentially his alternative proposal or alternative position. Let me deal with each in turn very quickly. First, on the issue of Section 64, ADA non-compliance. His objection essentially surrounds the redaction of names in the list of creditors and the letters of support, which then don't allow him apparently to understand the size of the debt or get evidence as to the quality of support. Your Honor, this objection is at best an objection to the sealing applications. It is not relevant to the scheme moratorium applications. The reason is because we are in the court's hands on the sealing applications. That information which he is asking for has been filed in court. If the court finds that in order to satisfy Section 64.4, that sealing should not be allowed, then the information is already filed in court and it would be disclosed because it will not be a sealed document anymore. It is on the e-litigation system and he would be able to see it. So, Your Honor, just as a first outset point to make, his entire objection on Section 64 ADA non-compliance is at best an objection to the sealing application and not the scheme moratorium applications. On a second level, I respectfully disagree with the objections raised. My learned friend cited re-TTI to say that creditors do need to consult with each other. However, TTI was a case involving the scheme meeting stage. It was not the scheme moratorium stage. Obviously, by the time you go for the meeting, different considerations apply. But more to the point, Your Honor, and here is where I think the nub of my sealing application comes in. PTI did not deal with issues of contagion, which are particularly relevant to cryptocurrency companies and cryptocurrency players. It also did not deal with issues as to sensitivity around the entirety of my client's customer list being something which competitors could take advantage of. Lastly, TTI as a decision did not consider or deal with any of the US case law and authority on sealing of customer names and the top 30 creditor list in the US. So, Your Honor, unfortunately, TTI as an authority, while helpful for, I suppose, a general statement of proposition as to what the balancing factors are, does not actually deal with the issue of sealing of this kind of sensitive information. The third problem with my learned friend's submissions as to Section 64 ADA non-compliance is his suggestion that the letters of support are redacted and therefore does not disclose the size of the debt, or the court has no evidence as to the quality of support. With respect, that is incorrect, because my client has expressly filed the percentages of support for each relevant entity. And I will turn Your Honor to that because I think it is important. Just for Your Honor's ease of reference, I will refer to my learned friend's bundle, volume 2. Volume 2 at page 271. The third affidavit.
Yeah.
Your Honor will see at volume 2, page 271, this is the third affidavit of Yang Zhou. We set out the express percentages in both number and value of support on a group basis, that is subpara 1, and on individual entity basis from subpara 2 onwards. We also expressly said that this is excluding any support from related parties. And last of all, we further got confirmation from Houlihan Lokey in writing. They provided an express written confirmation by way of email, which is enclosed to the affidavit, that these percentages were calculated excluding related parties. That the lists and so on were excluding related parties, Your Honor. So, Your Honor, the last thing I will say is, at this stage, yes, I fully agree with my learned friend, and I disclosed this at the outset, that the percentage support is not overwhelming, Your Honor. However, Your Honor should compare that to the list of supporting creditors and list of objecting creditors. In effect, Your Honor, most of the creditors haven't responded to indicate support or to indicate objections. We have a grand total of 2 objecting creditors, one being derived. But the vast bulk of creditors have actually not responded. It is in that context, Your Honor, that I suggest that even though the percentages that Your Honor sees here are perhaps not that high, when Your Honor compares it to the level of objections, I would suggest that this indicates that actually there is some creditor support here, and Your Honor has confirmation that this is support from independent creditors. Your Honor has that confirmation from Houlihan Lokey itself. The last thing that I will say on this issue, Your Honor, is that, as Your Honor knows from the I.M. Skaugen case, the court does not take a headcount test at this point. And that while it is important that we do at least look at the level of support, that does not mean that even if there's an objection from major creditors, that necessarily means that no scheme moratorium should be allowed. Your Honor, I will move to the second objection of my learned friend, that relating to substantial connection. Now, my learned friend has made much reference to the issue of Yang's residence as the sole director of effectively each of the entities. And my learned friend, I'll take Your Honor to the page that he referred to. This is the same volume, volume 2, at page 619. This is my learned friend referring to the fact that on this page at 619, Yang Zhou's address is listed as an address in Hong Kong, I believe. What my learned friend did not refer to are 2 other pages. First being the page very like just before this at 618, where Your Honor would see that the registered office address in the second half of the page is listed as 6 Shenton Way, Singapore. Now, my learned friend complains that maybe this registration was on the 23rd of February and was very late. But my clients cannot be seen to be doing this just as a by the way to help the restructuring, because they have expressly gone on affidavit to say that we were actually carrying on business from this address, this 6 Shenton Way address, even before this date, but had in fact not registered themselves as carrying on business in Singapore. Now, had my clients not been genuine, they would not have made that admission on affidavit in the first place, because that exposes my client to potential issues. So that's the first point that I would make. And the second point that I would make, Your Honor, is my learned friend did not refer to another page which shows an updated address of Mr. Yang Zhou. That is at volume 1, page 128. Volume 1, page 128, Your Honor should see a business profile of Babel Asia Asset Management. And it expressly shows Mr. Yang Zhou's address as being an address in Singapore.
All right, but you're kind of like sliding away from the point that we're looking at Moon Alpha and his personal address vis-a-vis Moon Alpha, though.
Your Honor, his address, there's no dispute that he is a director of Moon Alpha.
Yes.
Even if the
Mhm.
Moon Alpha search as of 23rd February showed a Hong Kong address, his address on this other search, albeit for another company, but it shows a factual address in Singapore.
For that company, but not Moon Alpha.
I understand, Your Honor, but his address is his address.
No, people have multiple addresses. That's not uncommon. They may have other offenses to answer to, but I don't
Yes.
know whether this is going to add anything to your arguments.
I see, Your Honor. So perhaps it would be more persuasive, Your Honor, if I referred to the fact that Your Honor has his Singapore arrival card showing that he came into Singapore as being a PR here. Your Honor has his employment pass in Singapore. Your Honor has a Singapore bank statement showing that he has a bank account in Singapore. I will just give Your Honor the page reference for that, Your Honor, without taking Your Honor to the...
For Moon Alpha, though, are these in relation to Moon Alpha?
Yes, Your Honor. Sorry, his employment pass is for a different company, Your Honor.
Yes, so as I mentioned, I don't think it's going to help very much if it's not linked directly to Moon Alpha.
Yeah. Your Honor, I think his employment pass is for the group.
All right, you can show me the employment pass.
Yes, Your Honor. Sorry, Your Honor, if I can just take Your Honor to the actual page itself. This is volume 2, page 131 onwards.
1-3.
Your Honor, perhaps I better start at 131.
All right.
This shows Mr. Young's entry into Singapore as being 12th July 2021. Your Honor would see on page 132, multi-journey visa issued. And then on 133, this one I should disclose, it says Babel Asia Asset Management Private Limited.
Yes.
So it is a different entity.
Yes.
But Your Honor, it is relevant, as in, Your Honor, the relevant inquiry is where is Mr. Young, regardless of who, like.
Well, he chose to register his Hong Kong address for Babel. He chose to do that. So he got to show some linkage to Babel to Singapore.
Your Honor, the last thing I was going to say on the issue of Mr. Young's residence is that he signed his affidavits in Singapore. So at least Your Honor has that evidence showing that he is here. And Your Honor can see that from volume 2, 272.
Oh, no, you don't have to take me there. All right.
Yeah.
I'll take your word for it that he signed in Singapore. All right.
Sure. Thank you, Your Honor. Your Honor, the bigger issue is that there are other connecting factors to Singapore in addition to what I have just thought about Mr. Young's residence. And Your Honor can see a list of those factors at volume 2, page 609. Volume 2, page 609, Your Honor will see paragraph 65. First is the fact I've already alluded to, which is Mr. Young is resident in Singapore. Second is the fact that the company has clients and creditors in Singapore. Now, my learned friend referred to the fact that at least where the private app is concerned, those were subject to Hong Kong law agreements. I agree with that, but as Moon Alpha's affidavit set out, there is other online business besides the private app. The third connecting factor that we referred to is that the company has been carrying on business in Singapore through Babel Asia Asset Management's premises at the same address which I showed Your Honor, which is listed on Moon Alpha's company search. Your Honor, the fifth factor, the fourth is again about carrying on business in Singapore, right? The fifth factor is about where the crypto assets are controlled by. Now, my learned friend has suggested that the lex citus should be determined on the basis of where the company is, as opposed to the individuals holding the private keys. Your Honor, unfortunately, every case which we've had so far, which has touched on this issue, has looked at individuals only because in those cases it was the individuals who were in question, not companies, as my learned friend said. But in our case, the special factor is this: the group, including Moon Alpha, consolidated its crypto. So Moon Alpha held its crypto consolidated with the rest of the group and ran that crypto out of Babel Asia Asset Management's premises in Singapore. So it is a mistake to just look at Moon Alpha in utter isolation because of the consolidated nature of how it ran its crypto and consolidated it with the rest of the group. Now, my learned friend objects to even that on the basis that Deribit apparently didn't know that Moon Alpha was being run together with Babel Asia, with the rest of the Babel group. With respect to Your Honor, I don't think that position is correct. Because if Your Honor looks at the underlying documents when first agreements were entered into between Deribit and Moon Alpha, it specifically said Moon Alpha Financial Services Limited, bracket Babel Finance. And then the contact details which were given, Your Honor, perhaps I should take you to the page for in this case. This is volume 1, page 261. Your Honor will see that at volume 1, page 261, this is the final page of the contract which starts on 258. Your Honor, in fact, I will go even earlier than that. I will refer to 254, volume 1. Your Honor will see at page 254, volume 1, this is a non-liquidating account agreement, which is the center of some disputes, between Deribit Panama and Moon Alpha. And Your Honor can see the description of Moon Alpha on page 254 right at the top. Moon Alpha Financial Services Limited, bracket Babel Finance. Now, I will say that it does say it's registered and incorporated in Hong Kong and so forth. But Your Honor, look at the page 257, which is the Annex 1 to the same agreement. It says this non-liquidation form incorporates all of the terms entered into between Deribit Panama and Moon Alpha Financial Services Limited. Now look at each of the contact details and usernames and main account and sub-accounts. You will see email address account, trade at Babel Finance. Username is Babel Finance and Babel Finance sub. Main account is trade at Babel Finance. Sub-account 1 is Chen Sing at Babel Finance. Sub-account 2 is trade at Babel Finance. So I really don't think you can say that Moon Alpha thought that it was dealing only with, Deribit thought it was dealing only with Moon Alpha as isolated from the rest of the Babel group. That has to be incorrect. Your Honor, I will just give you page references, but there are also other exchanges, including Telegram chats, where they expressly make reference to accounts in the name of Moon Alpha as being Babel Finance, Babel OTC, Babel Earth, and Babel Structure Sub-Account. Your Honor can find this. I'll just give Your Honor the page reference. Volume 3, page 62, page 68, page 92, and page 12. Where on page 12, it makes reference to correspondence between Deribit and various representatives of Moon Alpha and or the Babel group. So, Your Honor, to suggest that Deribit didn't know that they that Moon Alpha had something to do with the Babel group, we respectfully disagree. Your Honor, that is I will now turn to their third objection, which is apparently the lack of bona fides. Your Honor, they have questioned why we want to redact the names of creditors when apparently presentation slides were sent to Parastate containing those same names. Your Honor, if I can just turn, Your Honor, to what those slides actually say. This is at volume 4, page 144.
All right, yes.
My learned friend says that we can't justify sealing because we apparently already disclosed the names of creditors on the far right of this slide. We respectfully disagree for two reasons. Firstly, this is not a creditor list. This is who our partners are. So, for example, if
Hold on, Mr. Yo, which 144?
My apologies, Your Honor. It should be at the top right of the page.
Yes.
The very top number in white. I have it in white. And below that, just below 144, Your Honor should see 90 in a gray color.
All right.
And on the right-hand side of the page, Your Honor should see selected partners, 100 plus exchanges / trading firms, 50 plus wallets, custodians, and so on. Your Honor, two very quick points I will make is, firstly, this is not a creditor list. This is a list of partners. Partners may be creditors, but may also have some other relationship. For example, the second category of partner is custodians. Custodians will hold crypto belonging to the group in custody for the group. That would not give rise to necessarily to a creditor relationship. That's the first point I will make. The second point I will make is at the bottom left of the slide, on every page of this set of slides, in fact, Your Honor will see strictly confidential. These slides were supposed to have been confidential. Now, if it's disclosed by Parastate in breach of confidence, that can't be my client being cavalier with the names of creditors. The next point that my learned friend makes about lack of bona fides is apparently that this process has taken 9 months and therefore shows a lack of bona fides. We respectfully disagree, Your Honor, and we have already explained this on affidavit. In fact, we were the ones who disclosed that we've taken this long. We specifically said, and I'll give Your Honor just a paragraph reference. This is First Yangzhou at paragraph 81. We set out exactly why it's taken so long. Because, among other things, our restructuring efforts were severely disrupted by the Chapter 11 filings of FTX in November 2022 and Genesis in 2023 January. That resulted in increased skepticism about traditional crypto lending business models, about a C5 business, Your Honor, and led us to need to adjust our restructuring plan to be more about DeFi. So that's the first point that I will make, that we've explained why it's taken that long. Second, Your Honor, we also have set out that we have gotten new money term sheets of 22.75 million. And we are in the process of getting more. But the point is this, we are showing some degree of progress. So to say that there's a lack of bona fides, that we are running this for fun, with respect, is not correct. Your Honor, my learned friend then complains about the improper inclusion of certain related party creditors in an earlier version of the top 20 creditor list. Now, first of all, my learned friend would not have even known about this had we not ourselves filed a revised list and come out and in full and frank disclosure to the court said, Your Honor, we have made a mistake. That's the first point. The second point I will make is in that list of related party creditors, when he complains about the second affidavit saying, oh, you know, Houlihan has confirmed that it's clear of related party creditors. We had 4 days, Your Honor, to file that second affidavit. from the point that derived filed their response affidavit to the point that we filed our second affidavit containing the statements which my learned friend complains about, we had 4 days to file that affidavit, Your Honor. So yes, there were mistakes, but we came out and corrected those mistakes on the very following working day, which was the following Monday. So, Your Honor, I don't think that it can be said that we lack bona fides merely because of the improper inclusion of certain related party creditors when we ourselves corrected that issue already, and we've explained why that issue arose in the first place. Also, Your Honor now has express written confirmation from Houlihan.
All right, Mr. Yeo, you've made your point. Carry on.
The very last point my learned friend makes about the lack of bona fides is apparently that there is some regulatory breach. Now, it is telling that the original regulatory breach that they alleged in their submissions at paragraph 38 was that we were engaging in fund management for collective investment schemes, because those collective investment scheme in this case is defined rather broadly, and that we had somehow breached that regulatory requirement. It is for that reason that in our submissions, we addressed that specific breach. And we also, out of abundance of caution, also addressed crypto lending, crypto borrowing, and offering of OTC derivatives for crypto. So we've addressed all of that. We've shown, Your Honor, that that is not regulated and is subject to express exemptions in the Act. Now they've changed to allege a different breach on the basis of 2 words in the description of in a website relating to priming services, I think it was. Your Honor, I will confess that I will need to hunt through the Payment Services Act to find the relevant exemption. But as Your Honor pointed out, MAS has not come after us for that. Nor is there any evidence that that prime services was being conducted in Singapore. And in fact, the relevant provision which my learned friend cites doesn't even mention the term prime services. So, Your Honor, I frankly, I don't know how to respond to that, only because all I've seen so far is 2 words on a website, at the like a footnote of a website. Lastly, Your Honor, I will deal with my learned friend's alternative position, which is if Your Honor grants relief, that it should be subject to a different timeline, that the monitoring accountant should be different, and that they should have a carve-out. Dealing with each of these in turn, my learned friend suggests that we should only have 6 to 8 weeks of a moratorium. Your Honor, that does not make sense, simply because we've set out the express scheme timeline, which obviously will take longer than that, including the obtaining of signatures to a restructuring support agreement and restructuring term sheets, including the entry into new money term sheets. Third, the timeline that it would take to enter into definitive docs, especially for new money investments. Fourth, after that, the actual convening application to court for leave to convene scheme meetings. And the paragraph, I'll just give you the page reference. It is 2nd Yangzhou at paragraph 76. With respect, with that timeline in mind, it does not make sense to only grant a 6 to 8 week moratorium. We will just end up having to come back before Your Honor and incur yet more cost and have another round of objections from derived probably. The second point that my learned friend makes is that he prefers a different monitoring accountant. He acknowledges that FTI are professional and so forth, but he prefers that there be somebody else looking at this, right? Your Honor, if Alvarez and Marcel is engaged, then we wouldn't be able to engage FTI at the same time. It would not make sense to have 2 sets of IFAs being appointed, in addition to Houlihan Lokey itself already, right? That's the first point. The second point is we still, up until now, don't know what the cost of Alvarez and Marcel is. I frankly don't know. To suggest that the company must bear this cost without us even knowing what we are engaging in is unsatisfactory. The last point that my learned friend makes is that he should be carved out from the moratorium. Your Honor, it makes no sense for every creditor attending today and listening in to be blocked from pursuing their claims by a moratorium, but my learned friend should be, as an unsecured creditor, allowed to pursue their unsecured claim. That will just incur further time and cost for the company, when it is a well-recognized principle in insolvency proceedings that if you are going to go through some kind of restructuring or insolvency process, it is much more efficient, cheaper, and to the benefit of all creditors to have that claim adjudicated by a scheme manager or some other independent professional. So, Your Honor, that carve-out makes absolutely no sense. Your Honor, I would like to address more, but I am cognizant of the time and the amount of attention I have taken from Your Honor to date.
All right. I think the other points are covered in your submissions. Hold on. Let me just try to work out what you're going to give a decision by.
Your Honor, if it helps, the moratorium should expire on the 5th of April. So if Your Honor would like additional time to make that decision, may I very humbly ask for at least an interim moratorium just to cover?
Yes, I'll be giving an interim order as well. I think the best course. All right, I think there are a few complex issues here. I'll need a little bit more time. So I'm going to give an interim moratorium to the 17th of April. (3 p.m.) Sorry, to the 17th of April, I will fix a hearing for my decision on the same day at 3 p.m. For me to give my decision. So the moratorium is extended on an interim basis and it's not to be taken to prejudice derived's position in any way subsequently.
In any way subsequently, meaning that at least
up to the 17th. After that, I may discharge it entirely, and then Mr. Burgess gets everything he wants.
I fully understand, Your Honor. Your Honor, can I just clarify that the interim moratorium will also exclude repossession of?
Yes, excluding repossession of the property.
Thank you, Your Honor.
All right, and could I have your affidavit from your client? Today's a Friday. Next Wednesday, good, Mr. Yo?
That would be the 5th.
Yes.
Yes, Your Honor.
All right. Affidavit by the 5th of April. All right. Liberty to apply to any parties if any complications arise in the meantime.
Yes, Your Honor. And just in the interest of disclosure, the affidavit will cover, with Your Honor's permission, of course, that I believe certain creditors had at one stage suggested that they would complain to MAS. So if I could have leave to include that in
yes, you can include that as well. Yeah, well, that's
thank
fine.
you. Thank you, Your Honor.
All right, thank you. Anything further, Mr. Burgess, that you need today?
Nothing further from,
all right.
from me.
All right.
Thank you
all.
for indulgence.
Thank you both for your submissions. All right, so I'll see you on the 17th of April, 3 p.m. for me to give my decision.
Thank you, Your Honor.
Thank you. Court
Thank you.
Thank you.
Thank you.